Let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.
Well, that is never a smart response when you are up for parole 20 years after pleading guilty to killing his wife. He has 10 more years left on that sentence. The ADA, Randall Myers, there, and he's going to tell the board what happened. We also have the appeal with all the details of what happened, and we will go through that at the end of his parole hearing. With that, let's jump in.
Paul Farinas, 172-985.
Okay. The way this is going to go is that I'm going to speak to you first, and then we'll let anybody for speak, which we have no one here in favor. We do have opposition, Mr. Randall Myers, Assistant District Attorney Jefferson, and Edna Amos, victim's mother, is here with us at headquarters, will be speaking, and Joanne Barton, victim's aunt, is here at headquarters but will not be speaking. Is that correct?
Yes.
Okay. All right, Mr. Farinas, tell us, why do you think we should parole you, and what you did to get yourself in this situation?
Committed a crime of manslaughter.
Okay, be a little bit more specific than that. I mean, what did you do? What happened?
The crime of manslaughter against my wife, Delinda Amos.
And why should we let you out?
I've done a lot productively through the years of being incarcerated. Been involved in a lot of programs, classes, mentoring, tutoring, and I think I'm a different person than I was when I first came in. Mindset, way of thinking, compassionate. And I would ask the board to please consider granting me a shot at another chance in society.
Okay. All right. First, we'll go to the victim's mother. To approach the podium, please, ma'am. Please state your name and relationship, ma'am.
My name is Edna Ames. I'm Delinda Ames' mother.
Okay, Ms. Amos, tell us what you want us to know, and please try to hold it on the bottom.
He objected. When he first did it, they said he had 30 years flat. He said the crime that she electrocuted herself. Her 11-year-old son found her body in the tub. She not was just raising her three, but also his two daughters. She would never ever get a chance to see her children graduate, get married, see her grandchildren. And he had, they have seen him say he's a changed person. I don't think so. Because my oldest grandchild still have nightmares, and he's 31 years old. And for a child to find his mother in that condition is beyond belief. You know, I don't think he needs to be paroled. He needs to do his whole 30 that they claim that he was supposed to be doing.
Thank you, ma'am. Appreciate you coming today. Next, we'll have Mr. Randall Myers, Assistant DA Jefferson Parish.
Good morning, Randall Myers, Assistant DA in Jefferson. We're opposed to Mr. Farinas' request for parole. As you just heard, there's victim opposition. Mr. Farinas, as noted in the judge in his opposition, had entered into a negotiated plea to serve 30 years for a violent, intentional, and carefully planned murder. and he staged the scene to try to make it look like an accident. And looking at what he's done since incarcerated, it doesn't appear that he's taken sufficient programs to warrant a release. The record shows that he's completed Living in Balance, True Freedom Program, and Anger Management. So based on that and the victim opposition, we are opposed to his request.
Okay, thank you, sir. Okay, this case has been assigned to Mr. Prater. Mr. Prater, would you lead us off in questioning?
All right, Mr. Farinas, tell us. I know you must not like to talk much, but I'm gonna try to pull it out of you. What have you learned in your classes about victims and victimization and that sort of thing?
Victimization, I guess is another form of bullying. I've learned compassion. That is not right. Helping people more, listening, understanding, finding out more about myself. And finding out more about myself enabled me to be able to help others with different facilitating of classes that I've done since being incarcerated. And I've strengthened in them areas since being incarcerated and involving myself with different programs to enable me to be able to speak to you today and stating that, you know, I'm not the same person I was when I first entered prison.
Okay. Well, anytime you've been somewhere 20 years, you're not the same person that you were before. You've got some good letters from staff at the prison and the sheriff's office. You got some good letters. You got some victim opposition, DA and law enforcement. You've only served 20 years of a 30-year sentence, and you took a plea bargain. What were you originally charged with?
Second-degree murder.
Okay. How did let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.
That's all the questions I got.
Okay, Ms. Renata, do you have any questions?
Mr. Farinas, how old were you when this happened?
I'm 30, 31.
And how old was your wife?
29.
How old was your, I'm sorry.
29, I think.
Okay. No, I don't have any questions, Mr. Freeman. Thank you.
Yeah, I just have one question. I see in the record that you were removed from state police. Is that correct?
Yes, sir.
And why were you removed from state police?
It was a fight with another inmate.
And that was in 2015?
Yes, sir.
That's all the questions I have. Is the panel ready to vote?
Yes, sir.
Okay, Mr. Prater, it was your case. You'll go first.
Okay, Mr. Farinas, it's kind of an unusual situation because you're still denying something that you pled guilty to, and that puts us in a kind of an awkward position in a way, but it makes it simple also. You served 20 years of a 30-year sentence. It was a gruesome crime. The 11-year-old could have been electrocuted when they found their mom. You don't seem to have a lot of remorse for what occurred, at least not that I could hear, and you have no admission that you had anything to do with it. And so something you pled guilty to. I have no question of what my vote is going to be, and that is to deny your parole.
Ms. Renatza?
I agree. My vote is to deny parole based on the negotiated plea and the opposition expressed today.
Okay, and my vote is the same due to law enforcement and victim opposition and the plea bargain. Mr. Farinas, your parole has been denied. Good luck to you.
Yes, sir.
And we're signing off at Wynn Parish. Thank you, Wynn, for accommodating.
Thank you.
Isn't that interesting? This man 20 years ago, he kills his wife. He tries to set it up where, oh, I don't know, the iron, she somehow happened. He allows his children to find her. I mean, we're talking about the epitome of a monster, evil, pure evil. 20 years later, he has a parole hearing that lasts all of about like 11 minutes. We could see parole hearings or commutation hearings for these type of crimes that go an hour long with the supporters and it's like, then this affair is just over before it even started. And one has to wonder what goes through. We'll go through the appeal. We'll get the details of this crime. What goes through the mind of someone who you just have to assume he took the plea. You don't take a plea deal that you killed your wife in a situation where if she like this, if you didn't do, come on, man, this is if there's any type of situation, you don't say, yeah, it really looks like I gave her an iron and she dropped it in the bathtub. Yeah, you're right. I'm gonna plead guilty for that because it's it's nice to see the ADA there because you hear the victim speaking, talking about her son who still has nightmares, and well, you can't heal from that. A little boy seeing your mother, a little daughter seeing your mother. It's just, and he sits there and he says, "Nope, I did not do it." I like the way the board handled this. Quick, snappy, get out of here. We're not going to waste any more time on you. And he's back in 10 years. And let me just go through this. I don't know. He probably can reapply for parole. They changed the laws recently. I'm not sure for this crime how long we'll have to wait. But if he does come back, we'll put it in the playlist, the return of playlist, where we keep track of returning offenders. So here's the facts of the case. We'll go through this. The defendant's conviction was the result of a guilty plea. A factual basis was provided by the state at the time of the plea. The state informed the court that at trial, on the merits, it would have shown that on September 3rd, 2004, the defendant killed his wife with the specific intent to kill or cause great bodily injury to her. And pursuant to this plea agreement, at the time he committed the offense, that he was acting in the heat of blood and sudden passion. In addition, the following facts were taken from the hearing on the defendant's motion for a preliminary examination that was completed a few days before his guilty plea. The preliminary examination was held on 3 days after the first setting. The grand jury had not yet returned an indictment. After the grand jury returned an indictment, the matter was allotted to another trial judge who heard the matter anew. The defendant and his defense counsel were present in court for all hearing dates. The state presented the testimony of Jefferson Parish Sheriff Officer Sergeant Donald, the lead homicide investigator, and Dr. Karen Ross, the Jefferson Parish Coroner's Office forensic pathologist and assistant coroner who performed the autopsy. The sergeant testified that officers had received a 911 call at approximately 6:46 a.m. that morning. Now, they list an address here, so I'm going to have to block that screen out, and that's why you're not seeing anything for a second. He saw no signs of force, just YouTube stuff, no signs of forced entry. The nude victim was lying in a bathtub filled with water, with her face, including her mouth and nose, above the water, and her head resting on the back of the bathtub. The sergeant saw a pinkish froth discharged from the victim's mouth and nose. A curling iron rested on the victim's pelvic bone. The curling iron and its cord were partially submerged in the water. The cord was attached to an extension cord. By the time Sergeant arrived, the police officers had unplugged the cord. The victim's hand was cupped over the curling iron. A cloth curler used to roll hair was clipped to the back of her head. Other curlers nearby, a mirror, and a prop was propped against the toilet and angled toward the bathtub. At the time the incident was reported, there were 5 children in the home. This is so true. It's so easily one of them. So many of them could have been killed by this. This is insane. An extension cord. This guy is just, he is the brightest. He's a sharp dude. Unbelievable. Yeah, because people go and they take extension cords and curl their hair while they take a bath in a hot tub. That's just something everyone does. Of course, the police are going to think that. Yeah. Okay. Sergeant learned that prior to his arrival, the defendant was there briefly. Later, the sergeant took video statements from the victim's 11-year-old son and 8-year-old daughter, the defendant's children. It was his biological children. The son stated that the defendant was aware that the son's mother intended to leave the defendant. The daughter said that she awakened during the night preceding the death when she heard yelling and the victim and the defendant arguing. She also heard her mother pleading with the defendant to put down the gun. She stated she observed both of them in the hallway, and at the time the defendant had a handgun. The sergeant said that while he was on the scene, Robert informed the police that he was the victim's boyfriend. Mr. Johnson suspected the defendant of killing the victim. He told the officers that the victim intended to separate and ultimately divorce the defendant. He stated that the victim had either secured or was in the process of securing an apartment. The officer went to the apartment complex and confirmed that the victim had filled out an application 2 days before her death, requesting occupancy as soon as possible. The sergeant said that 6 weeks after the death, the defendant gave a statement after being advised of his Miranda and waiving them. The defendant said that he left the residence at 1:30 a.m. on the date to go to work. He stated that his wife was pouring a second bath when he left. The sergeant stated that he obtained a statement from a neighbor who saw the defendant later that morning. The neighbor's bedroom is located in front of the residence, and her window looks out onto the street. She told the officers that on the morning of the death, approximately 5:30 a.m., she was alerted to the revving of an engine on a large truck. She saw the defendant seated in the truck for a matter of minutes. The windows in her room rattled, and she considered going outside and approaching the defendant as he pulled off before she could do so. Dr. Karen Ross testified that the victim died as a result of a homicide. She attributed the cause of death to components of drowning and strangulation, but she cannot rule out electrocution. She stated that she definitely had evidence of drowning and strangulation. In her opinion, the victim died as a result of homicide violence. Yeah, she definitely strangled herself. And the whole thing is so insanely dumb. This guy's, as you can tell, there are sick people out there. And I don't know why they gave him a plea deal, because he's getting out in 2034 if he does his full term date. And then what? On June 19, 2006, the trial judge entered a guilty plea. Also, the defendant and his counsel, the trial judge, executed contemporaneous written acknowledgement and waiver of defendant's constitutional rights. Okay. He was 35 years at that time. Can you imagine? Basically, he thought the judge, in his mind, he thought the judge wouldn't give him all that time when he took the guilty plea. And then when he got, he's like, what? I got 30 years? What? And then he appealed. Clown. It's, thank you, Sir Richard, for providing this appeal. So many times in plea deals, you don't get appeals, but He appealed the sentence, and for some reason he was shocked he got 30 years with parole eligibility after serving 20. And you would think all the time he has to prepare for this parole hearing, and he decides, you know what, I'm just gonna say I didn't do it. That's gonna be my strategy. But we see everything in these parole hearings, and if you want to see more, make sure.
I want you to answer without saying what you was charged with. Are you an ex-offender?
Yes, sir.
You know, I'm gonna go back to you. So are you saying that nothing happened between you and Ms. Holmes? Is that what you're telling me?
Anybody?
Okay, well, a 7-year-old can't give you consent. Did you have any contact with Ms. Jones that was inappropriate?
Yes, sir.
Sir, what did you say?
Yes, sir.
Okay.
Yes, you heard that correctly. And we often see this, especially for those who haven't yet completed their SO program. See, they haven't yet been educated on how to properly communicate to the board. And we can get a deep insight into the minds of those who do this to little ones. Let's jump into a parole hearing for a man who's serving a 25-year sentence for doing this. I'll unpack it at the end.
I have Mr. Jones classified as a first felony offender with a parole date of 9/25/2024. Full term date of 10/29/2028. I'm gonna correct myself. Your parole date is 1/27/2025. Full term date is 10/29/2028. You're in there for 25 years on the charge of forcible rape. Does that all sound correct?
Yes, sir.
Okay. Mr. Jones, tell me what you did to get yourself into this situation, and why do you think we should let you out today?
First of all, I made a decision that I shouldn't have made, and I think you should let me out because over the last 21 years, I take responsibility for what I did, and I did everything I can to better myself. Due to the nature of my charge, I wasn't offered many programs, but the ones that I were offered, I took. I got my GED. I graduated college. Took a risk management class. I completed a inter-work program for the airmail company in which I work for right now. And if given the chance, like I say, I spent 21 years of my life behind bars for a decision that I shouldn't have made. And if given a chance, I won't make a decision again, and I won't let y'all down. I know y'all probably heard all this before, but I'm asking not to be judged by my actions, judged by those that came before me. Because I know there's a lot that messed up and, came back, but, that's not me.
Okay. Mr. Jones, what was your original charge?
They had me
Okay, and you pled to force rape?
yes, sir.
Okay. How old are you?
I'm 45, sir.
I've been assigned your case, so I'm gonna lead in questioning when we get to that. But right now, let's speak to those who are in opposition. Miss Jonetta Anderson, victim's mother.
Yes.
When we came in, they asked us whether we were in support or opposition. I said that I wanted to hear everything before I made that decision, but they put us on the opposition side. My daughter is now 28 years old, and I leave the decision to her to speak for herself at this point.
Okay. Your daughter had not requested to speak. Do you want to speak now, Ms. Holmes?
I can.
Okay, what do you want us to know, Ms. Holmes?
I just want you guys to know that whether he's granted parole or denied, he's gonna have to come home anyways. So whether it's now or in the next 4 years, he's coming home. I don't feel threatened. You know, it is something major that has transpired, but he has been there 21 years. And I trust that he changed and that, you know, he come home whenever it is, he comes home and he just does what he has to do to continue hopefully bettering himself.
All right,
And
thank
that's
you.
all I have to say.
Okay, Mr. Randall Myers.
Good morning, Randy Meyer. The district attorney's office is strongly opposed to his request for parole. Mr. Jones, 7-year-old child, he faced aggravated charges and faced at least a life sentence. He pled guilty to the forcible and was given to 25 years. We look at what he's done since he's been incarcerated, and you know, it's very concerning that he actually has a pretty decent, pretty good conduct report, except back in 2016, he had a sex offense. That is very concerning to me. He has not taken sex offender treatment. That's very concerning to me. I think Mr. Jones should spend his life in jail, but he got the break and sentenced to 25 years under the forced rape statute. I spoke with Miss Holmes, the victim, yesterday, and she agreed with me that he should not, if he is released on parole, which again we're opposed to, that he have no contact with her or her children. They are family, so we can't say that he has no contact with her family, but at least with her and her children, there should be no contact. But again, we are strongly opposed to his request. We think he needs additional programming before he's released. And the 2016 sex offense is very concerning. Thank you.
Okay, appreciate it. Your case has been assigned to me, so I'll be leading into questions, Mr. Jones. First and foremost, I wanna ask, have you completed the 4 phases of sex offender treatment?
No, sir, I haven't been anywhere where I was offered that program.
Okay. Because we definitely need to get you to that program. It's you know, it's very concerning to me that you haven't had that program. It's real good and it's something that needs to be completed. Okay, so Mr. Jones, do you admit that what went on happened? You did molest Miss Holmes?
I admit that I did not rape anybody.
Okay, well, how do you explain her getting a sexual disease from you?
I was never diagnosed with a disease.
Okay. Were there any drugs in your life at that time?
I was using drugs, yes, sir.
Okay, what were you using?
Sir?
What were you using at that time?
Marijuana, cocaine.
Okay, have you ever had any treatment for your marijuana or cocaine problem?
No, sir.
Okay. You feel like you're an addict?
No, sir. I haven't used drugs since I've been incarcerated, and I didn't have a problem.
Okay.
I used casually.
You know, I'm gonna go back to you. So are you saying that nothing happened between you and Miss Holmes? Is that what you're telling me?
I didn't hurt anybody, sir. I'm not saying nothing happened. I'm saying I didn't hurt anybody.
Okay, well, a 7-year-old can't give you consent. Did you have any contact with Miss Jones that was inappropriate?
Yes, sir.
Sir, what did you say?
Yes, sir.
Okay. Your static 99 is a moderate risk, that's also a little concerning because most of them grade out just low, but you grade out as a moderate risk. You do have the sex offense on your record from 2016. Where would you live if you got out?
I would be in Natchitoches, Louisiana.
Who you gonna be living with?
My girlfriend.
Where's she at today?
Work.
She knew you had the hearing, she couldn't come?
Yes, sir.
Okay. I have no further questions. Does either of my colleagues
Yes.
have a question?
Mr. Jones, excuse me, Ms. Renata, did you want to go first?
I do not. No, I have no questions. Thank you.
Mr. Jones, you pled guilty, right? But you're saying now that you didn't rape anybody. Do you know why that charge was?
No, sir.
You think you're a sex offender?
I was charged with sex offender, yes.
Are you a sex offender?
Yes, sir. I was charged with sex offender, so yes, I'm a sex offender.
Okay, I want you to hear, I want to hear it. I want you to answer without saying what you was charged with. Are you a sex offender?
Yes, sir.
How many times did you have a sex with this 7-year-old?
Damn, one time, sir.
I don't have any other questions.
Okay, I have no questions either. Is the panel ready to vote?
Yes.
Yes.
I'll go first since I was assigned this case. You know, Mr. Jones, you definitely 100% need your sex offender treatment class. I don't think you understand things. First off, the 7-year-old cannot give you permission. So my vote today is to deny. No sex offender treatment, your history in 2016 and your moderate risk on your sex offender static 99, along with opposition from law enforcement. My vote today is to deny. Mr. Knoxon?
Yes, Mr. Jones. There has also been opposition expressed by law enforcement and the Attorney General. So based on that, my vote today is to deny your parole.
Mr. Craig?
Yes, sir, Mr. Jones, you're either in denial or you're dim-witted. And you need to figure out which is which. And I'm in denial. I think you need to face up to what you did, the seriousness of it, before you should even be released at your full-time date in 28. But that's not up to me, but I'll quit the sermon and tell you deny.
All right, today your parole has been denied. Good luck to you.
All right.
We are signing out at Natchitoches Parish Detention Center.
What a symphony. It's like an orchestra playing, watching the way that the board handled this. They went through this hearing so quickly. You had Mr. Freeman that just did his thing perfectly. Miss Renata not holding back, not using her poker face. She looked disgusted. And then you have the sheriff finish it off with the coup de grace of like, come on, It's what was it? The last thing he said, I loved it. You are either in denial or you are dim-witted. And then of course, let's not forget our trusted consistent, always showing up to all the hearings in his parish, Mr. ADA Randall Meyer, laying down that facts of the case. Now, I don't have any facts on this case, but I will go over some good news on legislation. But if they said that there was some type of thing transmitted, you got to believe that. You can't believe a word that he says. You can see here, he's actually sticking with it. No, I didn't do that. I didn't do that to her. Oh, yeah, well, it was consensual. I mean, and here's the thing. The sheriff said either you're in denial or dim-witted, and maybe it falls under the category of dim-witted, but it might actually simply just fall into the category of he hasn't learned because he didn't attend his programs. He hasn't learned what to say. If he had gone to the programs, there's a really strong likelihood that he would have gone in there and said exactly what he needed to. I don't think this parole board would have paroled him regardless because they seem to actually have some common sense. I mean, like how the sheriff said you should do your full term date, but I can't even decide that. And but we have seen other parole boards grant like, oh yeah, this was a great interview. You definitely are cured because you know better now. And this board knows that that's just not true, which is interesting because Renata and Freeman are of the old guard. So I don't know what's changed, but it's like new governor dictates, I guess, how things are. I don't know. Now, I don't know. No board in Louisiana would have ever granted him. He completely it was just the worst parole board hearing that you can possibly have seen. Can you imagine sitting in there for 23 years or something and to get up there and say, well, I didn't do that. I just did this, because it was consensual. His full term day is 2028, but it's good time. He's getting out in a year. Can you imagine? And this is the thing about legislation, about laws, about plea deals. It's like the judge and the idea, well, we'll kick the ball down the road, but eventually he's going to get out. Yeah, like he has a girlfriend. She doesn't show up. It's funny. She who knows how long she's been dating him. And all of a sudden, if you take for his word for it, that he actually does have a girlfriend, imagine she's like, wait a minute, maybe I shouldn't. This is not good. He actually can get out. Uh-oh, I'm not going to show up. Either that or he made it all up. But let's go over the legislation real quick. This is the good news. Because if you recall, when he was sentenced, the maximum he could get for a second-degree sexual assault was 25 years. Well, as of January 2023, the maximums increased to 40 years. So a judge could actually have given 15 more years for this crime. And as you see, 25 years, it goes by. It goes by fast. And all those years, it makes a difference. So that's the good news. Legislation is it's taken a long time, but it is nice to see when it's upgraded. And they talk about what it is. Obviously he took the plea deal. It was supposed to be first degree, which would have given him a life sentence. And what is frustrating about it is that it does allow the legislators still allow a judge to say, you know what, the minimum you can give is 5 years. So a judge could still give 5 years. They want to give, I guess, again, that decision up to the judge. And the maximum the judge can give is 40. Can you imagine? But and You know, there's so much. It's like when you watch a Law and Order episode, and they go through the classic process. There's the police, and there's the detectives, and then there's and it goes through the process of it. But they don't talk about the legislation part of the criminal justice system and how judges' hands can be tied, and how so much of it goes back to this whole other layer that many of us, or at least so many of the public, really are not aware of. And I think that if others became aware of it and said, wait a minute, you're telling me that there are lawmakers that actually say that a maximum sentence for carnal knowledge of a juvenile could be 10 years, or incest, the maximum sentence could be 20. Why is that? Why are you setting the maximum for crimes that could be so horrendous that they're almost unspeakable? So that's part of doing this. And thank you, Sir Richard. I wish I had more information, but I think that we got the full picture. The board did their job. Randall Meyer did the job, and the sad part is the reality of the situation is that he will be walking the streets of Louisiana next year. He's not going to take any programs. He literally has the same mindset that he did when he got set in. So all it really was one giant metaphorical kick of the ball down the road with this sentence. And that's the sad reality with that.
As y'all went through it some, they had an assault battery, assault on a teacher, battery, second-degree battery, simple battery, and then the second-degree kidnapping charge. I tried to find out about his prison record, and wasn't able to because the record indicates that he lost 414 days of good time, but I didn't see anything with regard to disciplinary reports that as to why he lost all that good time. Mr. Rhea says that he never got another disciplinary report once he left Tallulah. Not sure when that is, but the record does show that he did have a disciplinary report when he was going through those courses, those educational courses.
I am happy that I am not going up against Assistant District Attorney Randall Meyer. He shows up to all his hearings, and he always is prepared to lay out the facts. And here it is. He's sharing with the board what's in this man's jacket, and it's not pretty. Well, I'll unpack it with the details at the end.
You are classified as a second felony offender. You were seeking a commutation of your sentence. You were sentenced in December 2007 in the 24th Judicial District, Jefferson Parish, for second-degree kidnapping. You received a 25-year sentence. You have a good time release date, March 20th of 2026. Is that information correct?
Yes, ma'am.
All right. Tell us, first we'll hear from you. We want you to tell us why you are submitting for a commutation of your sentence. We'll hear from your family members, and then we'll start the interview process, and we'll ask the DA's office to close it out for us.
Okay.
So tell us why are you in jail, and why do you think we should grant you some relief today?
Good morning, first of all. And I'm in jail on a second-degree kidnapping, as you all know, serving a 25-year sentence. I've been down 19 years and 4 months, I believe. I believe I should be granted a clemency because I'm not the same 25-year-old person that committed this crime. I've come a very long way, and more than anything, I've been nothing but remorseful and regretful for any part that I've played in that committing that crime. I've dealt with this every day for the past 17 years, and I wish there was a way that I can turn things around, but I can't. All I can do is try to better myself the way that I've been doing, and hopefully get this chance. I'm always working on myself, always. When I was at Tallulah in Madison Parish, I was one of the top trustees there, if that's worth anything. And I was also kind of liaison between the COs and the inmates whenever anything went wrong. I started several programs, if that's on the file, as far as religion based. I helped start the Christian ministry program under Chaplain Richard Doyle over there, and I also helped start the Islamic program. This is not who I am. I own up to my mistakes, and I won't even call them mistakes, bad decisions, because I knew what I was doing and I went in and I did it. I can't make up for it, but I want you all to know I am redeemable. I'm not just a throwaway. I have a lot of people who really love me and depend on me. And like I said, once again, to the family, the victim, I really do apologize and I'm sorry for my actions. And I hold myself accountable. Thank you.
Well said. So let us hear from your brother first, Latrell.
Okay.
All right, Mr. Freeman.
Okay, Mr. Lee, how old are you?
I'm 44,
Okay, and how long have you been in jail on this charge?
19 years and 4 months.
So how old were you when you committed this offense? 25?
Yes, sir, 25.
Okay, have you gotten your GED since you've been in prison?
I had my GED prior to coming to prison, but I have been enrolled in 8 semesters of Ashland University.
This is a big question I got. Why did you lose 414 days of good time?
Unfortunately, I was at Tallulah for almost 13 years. And be honest with you, it's a spacing thing. And as soon as I moved from where I was at, I've never had a write-up again. If you all are familiar with the history of Tallulah, it's chaotic. And I slept in the area that they refused to move me from. And I tried to remove myself several times, the right way, the correct way, and they refused to move me. So I kept getting wrote up for it said, I believe it was cell phones. I never owned a cell phone, but I kept getting wrote up because of the person that slept over me. And as soon as I was able to move, as you can see on the record, I've never had another write-up again. And that took 6 years before they would even allow me to move from a different bed to a different dorm. And I've never had a write-up under any circumstances ever since.
Okay. And so tell me, what was your role in this kidnapping? I've seen different statements from you, from her, from the other guy, Mr. Signal. What happened?
First off, I went in unknowing what was going on. And once I saw things unfolding, that's where I fault myself, because I saw it and I didn't do anything about it. I accept full responsibility for that. And even afterwards, I didn't go to the authorities. I accept my fault. I could have done something before everything snowballed and I didn't. I was asked to drive to one location, and while in the process of going to that location, they asked me to make a stop. And once I did, that's when all of the other stuff transpired, and they brought Mr. Lawrence to the vehicle, and he looked me in the face the way that I'm looking at you all, but in person. And I didn't do anything, and I'm wrong.
You're saying you didn't have the gun?
I never had a gun, never owned a gun.
And you didn't get out the truck and make him get in?
No, sir. That was Mr. Signal.
The signal wasn't there. Y'all
Yeah,
had dropped him off because this guy knew him.
no. Mr. Signal was in the bed of the truck. Mr. Signal was in the bed of the truck.
So he's the one, he jumped out the bed and put the gun on the guy and told him to get in?
Melanie Ann Brown walked Mr. Lawrence to the.
Right.
Can you hear me?
Yes, sir.
Melanie Brown walked him to the truck. I'm still sitting in the truck. Mr. Signal jumps out the bed of the truck. Mr. Signal had a gun. I've never had a gun in my life. And when I saw everything unfolding, like I said, I accept my fault in that. I didn't do anything and I could have.
But did he get in the back of the truck?
He got into behind my passenger seat. I had a quad cab, I believe it's called.
Right.
And he put him back there. When he laid him on the ground, well, on the floor of the truck, he sat back there with him. I was the one driving. There was no way that Melanie Ann Brown was in the passenger seat. I was driving, and he still had someone in the back with him that he admitted.
All right, now, but you said that he was in the bed of the truck, right?
Yeah, Mr. Signal was in the bed of the truck on the way there.
Something getting ready to go down.
Excuse me, I couldn't make out what you said.
So you knew something was getting ready to go down because ain't nobody gonna go get in the back.
Yes, sir. Yes, sir. At that point, I did.
Okay. When did he get in the bed of the truck? When y'all pulled up to the store, or you been riding back?
When we pulled up to the store.
All right. So Mr. Lawrence personally identified you, so he's the victim in the case, which I want to note for the record that he is very opposed. He still has burn marks on him, and I mean, he definitely went through a terrifying incident. I mean,
he didn't deserve.
Were you at the house with them at all when they were calling for the ransom?
Yes, sir. Melanie left and went to a bar or something and made one call and came back.
Right.
And that's why, like I said, I accept my fault in not doing anything.
Okay. Had they promised you any money out the kidnapping if the ransom was paid?
Yes, sir. Mr. Signal did himself.
Okay. I'm looking at your rap sheet. Okay, I see you had a sexual battery charge. What was that about? You got sentenced and found guilty on it.
I had sexual battery and I had unauthorized use of an automobile in 1999. I was 18 years old. I had sexual contact with someone that was 4 years younger than me, I believe.
And what about the battery on a school teacher?
Verbal battery. Verbal battery, yes. I had words with Miss Delosa Mocklin. I remember the school teacher name. She was my English teacher.
And you had simple burglary also. Okay.
As a teenager,
were you on any drugs, anything at that time?
No, sir. I don't drug. I promise you I don't drug.
Okay, so you've been in a parish prison. How long you stayed in parish prisons?
I did 3 years and 4 months for the sexual battery and the unauthorized use of automobile.
No, I'm just asking, how long have you been, since you've been incarcerated on this charge? Have you ever been to a state institution, or it's always been?
Always been parish facilities, from Jefferson Parish to LaSalle, to Madison, to River Bend, to here, which is Cleveland Parish.
You have lots of support. I want to note that. And like I said, you have victim opposition. You have law enforcement opposition. Looks like you've done right a little bit less than 80% of your time. I have no further questions.
Any other questions? I made a note. I wanted to tell you, Mr. Rhea, that I made a note. College transcript, great personal achievement. So congratulations on that. That was included in our record. But I would like to ask you, you have a good time date of March 20th, 2026, and you're seeking a commutation of your sentence. What exactly are you asking for?
Well, I actually filed 4 years ago. I understand COVID slowed the process of a lot of things. I just would like to It's my fault that I missed out on all of my life and my children's life. My daughter recently turned 21. My son is 20. I just wanted to try to be home a little bit earlier and spend time with them. I mean, no one knows when that number's going to come, but I would just like to return home to my family a little, sooner than later, if possible. And I've tried to do my best to make sure that I stay on the right path the entire time that I've been incarcerated. And I'm not sure if you have gotten the letters of support from the lieutenants and the captains that I've always worked under from the 3 different facilities, but the paperwork from my past is not who I am. Those are just some terrible decisions that I made. And like I said, I own up to all of them. I regret everything that I've done. And I'm just hoping that you all can see that I'm redeemable and I'm worth giving a chance to.
Okay, all right. Well, we're going to ask the DA's office to close it out first. Mr. Meyer.
Good morning, Randall Meyer, Assistant DA, Jefferson Parish.
Good morning.
We're opposed to his request for commutation of his sentence. Looking back at his arrest history, as y'all went through it some, they had an assault, sexual battery, assault on a teacher, sexual battery, second-degree battery, simple battery, and then the second-degree kidnapping charge. I tried to find out about his prison record and wasn't able to because the record indicates that he lost 414 days of good time, but I didn't see anything with regard to disciplinary reports that as to why he lost all that good time. Mr. Rhea says that he never got another disciplinary report once he left Tallulah. Not sure when that is, but the record does show that he did have a disciplinary report when he was going through those courses, those educational courses. I don't know. In his application, Mr. Rhea says that he had one disciplinary report. I don't know if that's the same disciplinary report that he had during the educational courses or not. The record, there's no DV history in there showing what disciplinary reports he's actually had. And I'm concerned with Mr. Rhea's statement of the fact in this case. It doesn't appear to me from what I've seen with the police report that he's being honest with the board of having no participation. His living girlfriend at the time stated that he was involved in the planning of the kidnapping and that they left the house with the intention, and Mr. Rhea knew this, and the intention to go and kidnap Mr. Lawrence. Mr. Lawrence positively identified Mr. Rhea as the person who exited the truck with the gun and forced him back into the truck, which is completely different than what Mr. Rhea says happens. And Mr. Signal was never charged with the crime from what I see. Looking back at the records, it appears that he had an alibi that was checked out and was confirmed. And he apparently, from what I'm seeing, was not in the truck when the offense occurred. He was not charged. Now, Mr. Ray's girlfriend was charged. She failed to appear in trial, and there's an attachment that remains open for her, even to this date. So, for those reasons, we're opposed to his request for commutation of sentence. And additionally, the victim opposition and the fact, I believe, as Ms. Farinas stated, he's got a good time date coming up relatively soon. Thank you.
Thank you. All right, is the panel prepared to vote? Mr. Freeman?
Yeah.
Mhm.
Okay, Mr. Ray, I look at your case, and the thing that really concerns me is the fact that he just brought up. The witness said you're the one that jumped out, put the gun in his face, told him to get in the truck. And the alibi from Mr. Signal was that he was not even at the location because it was premeditated and they knew that he would recognize him. My vote today is to deny criminal history and law and victim opposition.
Mr. Tillis,
I concur.
Ms. Stapleton,
I concur.
Mr. Prater.
Concur.
My vote, is to deny based on the proximity of your mandatory good time release date. You have a release date. So, my vote today is to deny. So it's a unanimous vote, Mr. Rhea. Your application for clemency, has been denied.
Okay, thank you.
What a difference it makes having Mr. Randy Meyer, the ADA, there, right? You know, it's a weird, also a weird hearing. He has his good time date March 20th, 2026. Now, that's in a year and whatever, a bunch of months, but which is of course nothing compared to everyone who's coming up for commutation hearings. We don't see that. Now he said that he applied for it and then it got kicked down the road. And hey, if they offered it, he'll take it. But in reality, if they would have made a recommendation to the governor to have this hearing, it takes time. The governor has to sign it. It takes a while. Sometimes we see it could take several years. So, he was just playing. He's just playing on House's money, I think, with this hearing, anyways. But I don't think he ever had a chance. We have seen so many hearings with those that come up in just the most esteemed situations. And here's one where he has 414 days loss of good time. Now, you might choose to believe his story, and it could be true. I watch plenty of prison YouTube things, and I hear you're stuck with the wrong bunkie, the wrong cellie, and you can be screwed. You'll lose all that good time. What can you do? And that's definitely possible. But the parole board, I think they see, we've seen hundreds and hundreds of cases, and you don't see these outliers that we so often. I remember first seeing this, just how surprised I was at how many inmates can go 20 years, even in Angola, and not get write-ups. So it's which always seems like an impossibility to me. You would think just a CO having a bad day would make sure you get a write-up. He's 19 years again. It's a 25-year sentence. He didn't kill anyone. Again, which is, it's like when you compare it to everything else. But then as I felt like Randy Meyer brings up the idea of how long his record is, and we've learned enough on this watching parole hearings that what even makes it into your jacket on your record is usually a watered down version of what happened. To start, I don't believe him when he says I was 17 and she was maybe 3 years younger. Richard has a notice that she was 13 and that it was full on SA. You heard from, to get a felony for being verbally abusive to a teacher, again, the odds of that happening, it's hard to, to have these things in your jacket. This is a life of pretty horrible crime. You got it. Now, I mean, to his credit, he seems to be doing great. I did not skip over his family support in any way of disrespect. I actually, one of his brothers, you couldn't really hear him, but the other one, he was prompt, concise. He said, hey, we're here, emotionally, financially, we're here for him. But what else is there to add? I'm trying to think. Randy Meyer said he's 5 violent battery and assaults in his record. 5. That's just, then he has the kidnapping thing because his girlfriend, he said, planned it. It's funny. We saw another kidnapping case with a woman today, and it almost seemed like they could have been the same cases, except in hers, someone passed, her victim died. I don't believe, it's the right move. They're not recommending to the governor to release someone like this so he can get a year and a half early. That was just never.
Mr. Signal was in the bed of the truck.
So he's the one, he jumped out the bed and put the gun on the guy and told him to get in?
Melanie Ann Brown walked Mr. Lawrence to the truck. Can you hear me?
Yes,
Melanie
sir.
Ann Brown walked him to the truck. I'm still sitting in the truck. Mr. Signal jumps out the bed of the truck. Mr. Signal had a gun. I've never had a gun in my life.
Wait, but you're saying now that you didn't wreck anybody. Do you know why that charge was?
No, sir.
You think you're a sex offender?
I was charged with sex offender, yes.
Are you a sex offender?
Yes, sir. I was charged with sex offender, so yes, I'm a sex offender.
Okay, I want you to hear, I want to hear it. I want you to answer without saying what you was charged with. Are you a sex offender?
Yes, sir.
Let me pull it out of you. How did your wife get the curling iron when she's in the bathtub?
To be honest, sir, I wasn't even at the residence when that happened. This is stuff I discovered through the first stages of when it started unfolding, and I wasn't even at the residence when it happened. I don't know how to truthfully answer that for you.
Did you provide her with the curling iron? I mean, you pled guilty to manslaughter. How did she get the curling iron?
That was a device that was in the household.
Did you have anything to do with her death?
No, sir, I didn't.